Hello everybody, welcome to Law Scope. In today's lecture, we shall be discussing adultery as civil or criminal wrong. As to my introduction, I am Sana Parvez, your legal expert for Hitbullseye. In the recent times, in February, in the beginning, the Supreme Court gave out a judgment, or rather, it is a clarification to the judgment which was previously given which was Joseph Shine versus Union of India, in which the court decriminalized the offense of adultery. So we all know that adultery is a moral wrong. There's no doubt about it. However, is it also a constitutional morality as well? Is it a breach of constitutional morals, or is it just a breach of the morals of the society in general? So, in order to have a look at this, we shall be studying adultery holistically as far as all the aspects of civil rights are concerned, all the aspects of criminal rights, and all the aspects of moral rights as well are concerned. So, firstly, adultery in civil law, it is a ground for asking for judicial separation as well as asking for divorce. It is also for the determination of the quantum of maintenance, and it is also adulterous behavior is also used, or it is also used to determine or ascertain the custody of the child as to who the child shall go to. Second, in criminal law, it is considered an offense, or it was rather considered an offense. In morality, it is considered an unbecoming conduct. What is an unbecoming conduct? We shall study further as we go on into the video. Okay, let us first discuss what is the significance of adultery as a civil wrong. Firstly, it is a ground for divorce or judicial separation. Under Section 10 as well as under Section 13, Clause 1, Subsection 1, it has been stated that it is any spouse who indulges in sexual intercourse outside of marriage while the marriage is still in subsistence he shall not be guilty of, but the other spouse can seek divorce or seek judicial separation on this ground that the other spouse has indulged in such activity. So it is clear that if they're using the word spouse, then that means that it is a very gender neutral thing. So if the wife is doing it, the husband can seek divorce, and likewise, if the husband is into an adulterous relationship, then the wife can also seek divorce against the husband. So here we see that it is basically to establish the fact that it is like a final nail in the coffin to a marriage that has mostly ended on the grounds that there is no matrimonial sanctity left in the marriage because one of the spouse is adulterous. So that is why it is fair enough that the other spouse would want a civil remedy, since the marriage and personal law comes under the civil matters and matrimonial matters. That is why it is given as a grounds. Secondly, for determination of maintenance, a person can ask for maintenance under, rather, a wife can ask for maintenance under Section 125, subclause 4 of the Code of Criminal Procedure. There are certain other provisions also in which in most of the cases where the wife can ask for maintenance, and in some cases wherein the husband can also ask for maintenance. In this regard, in this regard, occasional acts of adultery, basically in this regard there are three things: adultery, refusal to live or with the spouse, and mutual consent and separation. So basically, if it is proven by the other spouse that she or he, in this case particularly she, is not living with the husband only because of the fact that the husband is adulterous, or the wife has taken back or reneged from the matrimonial home because of her being adulterous, and she's not living with the husband. In that case, if the wife is at fault and if the wife is living in adultery, then she shall not be given maintenance. So this shall become a ground for determination of however much maintenance is to be given to the wife. So, in this regard, there was an update in April 2022 in Pradeep Kumar Sharma versus Deepika Sharma, in which the Delhi High Court stated that herein, where the adultery is being used as a matter to cut the wife's maintenance, it has to be shown that it is not occasional adultery, or it is not just one incident of adultery. It has to be shown that the wife was living in adultery. That is to say that she was in a continuous extramarital relationship per se, and in that case only she can be not given or not entitled to maintenance. The last point is for the determination of custody of the child. So uh, basically, wherever another spouse, wherever there is any proceedings going on for either divorce or judicial separation, or just for a separate residence also, then what is to happen is, for the if there is any question of determination of the custody of the child, then the custody of the child would go to any spouse who is not living under adultery. So this was with regards to adultery in civil law. Now let us come to adultery in criminal law. In criminal law, under section 497 of Indian Penal Code, adultery has been defined as such. Let us go through the definition and read it point by point. Adultery: whoever has sexual intercourse with a person who is and whom he knows or has a reason to believe to be the wife of another man. Meaning to say, another person, a third party, having sexual intercourse with the wife of a certain man without the consent or connivance of that man, the husband. Such sexual intercourse not amounting to the offense of rape, meaning to say that such intercourse should be with the consent of the wife, is guilty of the offense of adultery and shall be punished with an imprisonment of a description of a term which may extend to 5 years, or with fine, or with both. Now, this is basically punishing a third party if he indulges into a relationship with a person which he knows or has a reason to believe that she's a wife of somebody else. So here the consent of the woman has to be there. Otherwise, the offense would amount to be rape. But if the consent of the woman is there, but the consent of the husband of the woman is not there, then the offense would amount to adultery. Here, there is one more important thing to be noted with this, which the section has categorically stated in this regard, is that in such cases, the wife shall not be punishable as an abettor. So, first of all, let us focus as this portion. In such cases, the wife shall not be punishable as an abettor. There are there are three important cases which happened before the Joseph Shine versus Union of India. The first one was Yusuf Abdul Aziz, in which the constitutionality of the provision was challenged, and also this particular phrase where they're saying in such a case where wife shall not be punished as an abettor was challenged. Here, the Supreme Court basically struck down this particular provision and stated that if it is committed by a man, woman can be an abettor also, because the Supreme Court basically put Article 14 in place and stated that if uh, a man is being punished for a certain conduct, if the man and the woman, the man who was a wife and the woman who was into the extramarital affair, if they were both at fault, then the wrong was committed by both of them. Then in that case, punishing the outsider or the third party or the man is not justified under Article 14. However, the judgment ignored the aspect which is given under Article 15, Clause 3 of the Constitution, which gives beneficial legislations benefit to women and children, and that is why this judgment was did not stay for long enough. Then came the Saumitri Vishnu judgment. In this judgment, the Supreme Court for the first time recognized that it is indeed, this provision of 497 is indeed causing gender discrimination, legislative despotism, as well as male chauvinism. So it is causing male chauvinism. Why? Because 497 does not criminalize husband's adultery. It is giving a free pass for the husband to become adulterous, but it is criminalizing the wife's adultery only. And that is why it is actually not, it can, on the prima facie, on the look of it, it can look as if it is being discriminatory, as if it is making the woman the victim, and it is unjust to the man. However, it is only under the garb of male chauvinism, uh, and the real discrimination which is happening in this case is basically against the woman. And why? Because husband's adultery, one, has not been questioned here, and secondly, a lot of primacy has been given to the husband's consent. So wife's agency, wife's her own identity has kind of been attacked in this regard. The second thing, question the however, in this particular case, Amitri Vishnu, the court stated that it is not a question of constitutionality, but it is a question of policy, thereby meaning to say that it is for the parliament to change the law if it wants, and it is not for the Supreme Court to state or constitutionally strike this provision down. In the last case, V. Revathi, the Supreme Court stated that it basically upheld uh, adultery, and it stated that it is not arming the husband or the wife with weapons against each other, because they are aware of the fact that the constitutional policy is preservance of marriage. However, it is allowing one husband to attack an outsider. So basically, outsider who breaks the matrimonial home is punished, and not it does not harm the spouse. However, this is also not considered very correct, because if an outsider is being punished, then the outsider woman who is being adulterous with the husband is not punished in this regard. So, the challenges which were faced in this judgment, in the accumulation of these judgments, and the challenges which were discussed by Joseph Shine versus Union of India, were basically, first of all, sexual relationships by married woman with another man outside her marriage without her consent of the husband is criminalized. Secondly, in an adulterous relationship, the man is punished for adultery, while the woman is not punished, which is again breaking Article 14 of the Constitution, and she's not even being held guilty of abetment of the same thing. Then, sexual relations by married man with an unmarried woman are not criminalized, and Section 497 accords primacy to the consent of the husband to determine whether criminality is attached to the man who has the consensual relations with the spouse of the former. So basically, there was a lot of primacy which was given to the husband's consent, leaving the woman to be husband's chattel or husband's agency. So, lastly, in section 497 of IPC, the husband could lodge a complaint, and the wife could not lodge a complaint, and this was categorically mentioned under section 198 of Code of Criminal Procedure. So therefore, the court first of all stated that that as the law progresses, we have to develop with time also. So at one point of time, adultery could have been an offense, but now we have to take into account the important developments of law, and the important developments of law which the court relied on in this case were, firstly, Navtej Johar versus Union of India, and secondly, Puttaswamy versus Union of India. In the first case, the Navtej Johar case, the Supreme Court has categorically stated that in protecting consensual intimacies, the Constitution adopts a very simple formula. It basically states that the state has no business to intrude into these personal matters. The state is going to stay out of the personal matters of intimacy. Secondly, Puttaswamy judgment, the right to privacy is an element of human dignity. The sanctity of privacy lies in the functional relationship with dignity. So, therefore, in this regard, uh, this judgment was considered in the light of Article 21 of the Constitution. It was stated that it was giving unnecessary control to a man, which of the agency of the wife. Her right to life and personal liberty was being taken away by the husband. It is somehow the statute confounds paternalism as an instrument for protecting the marital stability, and it defines the sanctity of marriage in terms of a hierarchical ordering which is skewed against the woman. So basically, a marriage, the court stated, is something of equality, and it does not have to be rendered into a hierarchy where the woman is on a lower order, or a woman needs the consent of a man while the man does not need the consent of the woman otherwise. So the question now, this was decided earlier. Now the central government filed a notification in this regard, asking the Supreme Court that okay, Joseph Shine versus Union of India has struck down 497 IPC. However, how does it affect the armed officers? And for this, we need to understand why should it have affected the armed officer is the fact that the armed officers are governed by a separate code. So the separate code consists of the Armed Forces Act, the Army Act, the Navy Act, and the Air Forces Act. They have court martials, and their conduct and their offences are basically criminalized or non-criminalized, or basically are judged by the court martials only. And civil courts have no intrusion or have no say in the same. So that is a particularly a perfectly separate order, and that is why we need to understand that it also punishes sometimes people who are guilty of unbecoming conduct. So under section 45 of the Armed Forces Act, of the Army Act, and under the similar provisions in the Navy Act as well as the Air Forces Act, a person can be punished if he is found guilty by his commanding officer of unbecoming conduct. Now, what is and he can also be punished for up to 7 years, 5 to 7 years of punishment, and he can also, in fact, be dismissed from services as well. Under Section 45 of the Armed Forces Act, the unbecoming conduct has been defined as any officer, junior commissioned officer, or warrant officer who behaves in a manner unbecoming of his position and a character that is expected out of him. So in here, they're not saying it is constitutionally, morally wrong, it is legal, illegal. It is a character which is unexpected of him, basically. On conviction by the court martial, if he is an officer, he shall be liable to be cashiered or to suffer such less punishment as in the act is mentioned. And if he is a junior commission officer, then a warrant shall be liable to be dismissed or suffer such less punishment as is mentioned in the act. So now, the Armed Forces Act, the Supreme Court said, is on a different footing because is from a different footing than IPC, as is applicable to the civilians, because the expression that is used in is in unbecoming conduct, something which is not strictly adultery because of Section 497 of IPC, but has been can be struck to be can be judged to be unbecoming conduct. So, in this regard, the court further stated that there are people under the army officer is expected to maintain a certain command structure. He is expected to set an example for the other juniors who are supposed to follow him. He is supposed to be a leader. He is supposed to be something of a higher level than any other civilians, and that is why we cannot exonerate him of any kind of bad conduct. His conduct has to be of the highest level. There are people under his command. The important factor is the cohesiveness of the unit, or the bonhomie and the fraternity of the unit has to be kept together. These are the people who are under your command are to do or die. What are the character that is expected out of you? It has to be more rigorous, more exacting than any ordinary person. You have to set an example, and in that context the command structure gets disrupted. If your unit feels that you are going in the favor of one person only, and if you're being disturbed because of adultery or because of any such unbecoming conduct, even homosexuality, then it can trigger nothing less than a mutiny also. And such cases have happened in the army. Here, the quote further stated that you're the members of a unit. You're supposed to act on command in a flash. You do not question the orders. In civilian societies, we question everything. We have individual identity and we wear diversity on our sleeves. Here, there's an American article which states that if a person does not have control over his own individual instincts, what are we to do in a combat situation when the time of reckoning comes? There is a breach of command structure. So here the Supreme Court has focused very much on this thing, that a man who is in the armed forces and who is expected the highest level of behavior out of him, if he cannot control his instincts, and if he's indulging into morally wrong things which are affecting his own discipline and also the discipline of the people around him, then that is going to cause a great deal of disruption in the army. And that is why, it being a moral wrong, it can cause any dismissal or any kind of other punishment to any person in the armed forces. So thank you. I hope you all understood the video. If you have any doubts in this regard, please comment below. And thank you and have a good day. We shall be back with more interesting topics.